material?
There are some materials that are at the back of the room, so please feel free to go ahead and check on the back and pick those up.
We pass them out.
Yeah, everybody should have the packet. I'm not going to read through them. I'm going to trust that you will read through them on your own to kind of get some of the information, and that way you have the information and the materials that are here for you.
Don't bother with that because it's just going to keep cutting out.
Yeah, Melvin, this is a mic problem, not a... We were trying to make sure that we have it for the tape, but maybe I'm going to stand closer to the... You said this has a mic also? I'll kind of be closer over here.
Okay.
All right. We want to make sure that there's a good recording. I do want to introduce the Deputy City Attorney assigned to advise your board. This is Ms. Alois Phillips. So she's your Deputy City Attorney, and you know, some of you, if you have legal questions, you can raise them with her. I'm the managing attorney for the division, so I've basically been with Neighborhood Council since they started. I'm going to make my portion of this as long or as short as you want. I'm here just as a learning experience for you at this point in time. You know, I think Hugo got across the point for you all that, you know, this is similar to a workplace environment. So you have to be cautious with respect to the interactions that you have among and between your fellow board members, among and between your board members with city employees, because these can have potential consequences, including removal from the board, including injunctions or restraining orders, including any of these other types of penalties that could come into play. So we want you to be cognizant of these issues that exist. And part of the reason for this presentation was to make you aware of that. This is something that you all need to be aware of as board members. It's important for your behavior and your conduct. The next issue, though, that we want to go over is just a general issues about the neighborhood council system as a whole. I'm going to give a couple wide parameters, and then what we'll do is we'll open it up for questions and comments. And you guys will be able to learn as much or as little as you want to know. I'm committed to 5 minutes or an hour, whatever you want, all right? But just generally, obviously, the neighborhood council system, it was set up under the city charter. So you're a city entity. That means that you have these roles and responsibilities that are set up by the charter, and that's to provide advice to the city government. So all these issues that come up in your neighborhood, you're providing your input and your recommendations on these matters as they come before your board. There's a number of other laws, as you may suspect, that kind of impact that process. Since you are a government entity, you have these rules like the Brown Act, you have the ethics training, you have Public Records Act. So all these rules kind of come into play, and they impact that process or how you get to the end result that you reach. With respect to, you know, the Brown Act, the Public Records Act, you have the materials there in front of you. You have materials on the website, so please feel free to look at them. You know, one thing that I like to talk about with the Brown Act that I'll pull out of there is just the idea about what an ad hoc committee is. So sometimes neighborhood councils kind of have difficulty with that concept and what it means. And so for each neighborhood council, you're all going to have a different number because all of you have different board numbers. All of you have a different number for a quorum. All of you have a different number for how you take official action. I think with yours, and correct me if I'm wrong, you're 21 quorum, you're 21 board members. What are you? 21
board members.
21 board members, your quorum 11, and you take action by a majority of those board members present at the meeting. Correct? Okay. So that means, let's take the example then. So if 11 is your quorum and you take action by a majority of those present at a meeting, the fewest number of people that you would need to take action is 6. Okay? 6 is your key number. Your key number in determining what your committee size should be, even with respect to determining when you have serial communications that are happening outside the board. If you have the 5 of you here have agreed to form a faction. I won't call it a faction. A group. And you want to talk about issues that are coming before the board all the time. And you promise that you're not going to mention anything to any of these other board members. Not a peep, nothing. Just between you two, you decide how you want to vote. You decide what the issues are. You're a group. You're a band. Absolutely fine. There's not a problem with the Brown Act in doing that. What can happen, though, what can be problematic with the serial communication is that, you know, everybody swears under blood, like, yes, I promise we won't tell. But, you know, if you're like me, you're going, hey, You know, once you breach that wall, once you've talked to somebody else, then you've opened up that whole problem. So our advice is, you know, obviously to refrain from having these serial communications outside of the meeting. It'll keep you on track. It'll keep anybody from raising a Brown Act challenge. The next thing, though, that with respect to that 6 is it also tells you the size of what your ad hoc committee is. You can kind of figure out if you stay at 5 people, they have to be board members. They all have to be board members. If you add a member, we had a member from the public who wanted to volunteer. And let's say you have this idea for an ad hoc committee and you want to put him on it. It destroys the ad hoc committee. You can still call it an ad hoc committee, but for purposes of the Brown Act, it's not an ad hoc committee. You have to follow the notice and posting requirements. You can still call it ad hoc, but for purposes of the Brown Act, it's not going to satisfy that criteria anymore. So you're going to have open and public meetings if you put that person on. If you have, you know your number is 6. Once you reach 6, you have concerns with board action. So that's what makes the determination of your ad hoc committee 5 and under kind of gets you how you know what that number is. Also, they have to be temporary. It has to be limited duration. It has to be like a defined issue, and it can only come back to the board with its recommendations. If you meet those requirements, then our members of the ad hoc committee here, they can go and do anything in the absence of having to have that notice and posted in accordance with the Brown Act. This comes in handy for being able to do some of the work that the board needs to do, you know. Sometimes you need a group of people, a group effort to be able to put something together, whether it's a report, whether it's gathering information. So that can kind of help you in getting work of the board done instead of always laying that on one person. Question?
Our committees have essentially functioned on an ad hoc basis with stakeholders. So we have a planning and land use committee. We have an education outreach and education community, libraries and community organizations. We have a outreach committee. There's a bylaws committee, and that's it. Budget and finance, but that's a standing committee.
Okay.
So what we basically did was at our one general board meeting, we voted to create these committees by looking at the kind of the total. And what we were going to do ultimately is revise our standing rules to make them match up with the quote-unquote ad hoc committee. Now, when you tell me the ad hoc committees have to be for a defined purpose and limited time, you know, now I'm like, well, we should go ahead and amend our standing rules. What was that? Well,
it's not going to work for a general matter. Like you can't have an ad hoc committee do all your planning issues, okay? But you can have an ad hoc committee that does the XYZ project at this corner that's applying for a conditional use permit, you know, that's coming before the city within 90 days. So the distinction.
I want to go back to the planning and land use. So the planning and land use committee has essentially been functioning, you know, on an ad hoc basis.
Can I speak to this?
Yeah, I mean, you're the chair. So
Well, the reason we were functioning on an ad hoc basis is because we're just basically reconstituting after, you know, a troubled period, and so it was considered to be temporary, but nonetheless we are dealing with the general issue of planning.
let's just start noticing them.
Well, we
They're
do
noticed.
notice
We
them.
notice them. We essentially function like a standing committee, but we've been calling ourselves.
Okay, when
72
I
hours notice.
let me clarify something. When I use the term ad hoc, I'm solely that I only mean the Brown Act ad hoc. Okay, you can call your committee ad hoc. I don't care what you can use that term, but if you're noticing and posting it, you're really treating it like a standing committee. The Brown Act makes in the Brown Act there's this distinction. And the reason I pointed it out is because that's it. It's either ad hoc or it's standing. You have two types of committees, okay? For purposes of the Brown Act, when I say an ad hoc committee, what I mean by that is that committee that's not required to be noticed or posted. The 5 of you can go meet at your house and discuss whatever issue that is that you need to do. Come back to the board and report your findings. But even if you call it ad hoc, okay, and it's not, you're noticing and posting its meeting, you're not using the correct word of what the committee is. It's a standing committee, and you're treating it like a standing committee. It's like if I call, this blue microphone, okay? I can call it a blue microphone. It's not a blue microphone. You're really treating it as a standing committee. So that's what I mean by the distinction.
May I ask this question? Then our last land use committee meeting, we had a motion to disband the ad hoc committee and reconstitute it as a standing committee. Do we even need to do that? Because we basically are functioning like a standing committee. Can we just drop the ad hoc?
Well, okay.
Because we are noticing, we're doing everything a standing committee should do. We have full membership.
Your committee was set up by the board, right? So under your bylaws, you have a standing committee. Now, when you're talking about the ad hoc committee, which committee are you referring to?
Planning and land use.
So it's the same committee.
It's the same committee.
All right.
In
So
other words, we're misusing the word ad hoc.
okay. So when is it that your planning land use committee was created under by? Is that just do you have a time frame that people have when they're seated on the committee?
No, we just thought it was just sort of provisional once we wanted to do that so that the membership would solidify, make sure that everyone was interested, and then we would convert essentially. I think that was the
Yeah, that was the plan.
So in other
Yeah.
words, we are a standing committee, we're just calling ourselves an ad hoc committee. Do we need to motion to?
No, don't worry. You could use a correct name from now on. Yeah, you don't need to do
For
that.
standing rules, we have a planning and land use, so
Planning, public works.
we would have to either go with.
So make it consistent. Clean it up so that it's clear. Otherwise, you'll cause confusion for the public. They won't, because all they see is the paper, and so they won't know like what it is that needs to be done. But yeah, you can set up your committees in your standing rules. You can do that there as well, and you can specify the duration. If you want to have, people will be appointed to the committees for 1 year until their successor is reappointed. So then that way, kind of after a year, you'll go in and you'll put new members on your planning committee. So I don't know that you have a time frame now, or you just kind of, when it comes up, your board decides to do it. But however it's filled, if your board decides who's on that committee, that even if your bylaws don't say, that's who determines when you're going to vacate it and fill it with somebody else.
Committee itself.
Wait, your board fills the members on the committee for the planning land
So
use.
does the stakeholders.
So you have an election, like a selection process for filling the
Chair
committee?
appointed them.
We just asked who was interested in those people. I mean, amongst.
Is that the agreed process by the board? Your board has agreed to that rule?
The board agreed to create the ad hoc committee, but we do have standing rules that have a certain amount of stakeholders and a certain amount of board members for them. So I think what's going to happen eventually is that we'll drop the ad hoc and go back to the standing rule that we have in the standing rules. And if we need to make modifications to the membership, we'll do that. But
Okay.
I think just the question is that we're going to move into what our standing rules currently have to be in mind.
But I don't think the standing rules dictate how the committee members are, well.
No, they don't. I think ultimately,
So in other words, we just said, would anyone like, because we need to get.
Yeah,
we
yeah.
need to do it very quickly.
Clean it up in your standing rules, how you want it to be appointed, That's a good process.
What we're planning on doing is, now that we've got a bylaws committee appointed, we're planning on revising the standing rules, revising the bylaws, starting with the standing rules because it's easier to do that. And there's a lot of things that we could clean up. I have a whole list of them.
Yeah, and have your committee work with Lois. She can look at it and give suggestions and ideas that you may have omitted or you need to add. Yes, some questions.
Yeah, I've seen a few neighborhood councils that have alternates in order for a committee and or a board to make quorum. And what is Dunn's position on that? Because I don't know if it's basically something that maybe
You can
should be
decide.
addressed in bylaws and standing rules, but what's Dunn's official position
You-
on?
You can decide. You can decide to have alternates. If you want to change it so that you have an alternate system set up for your board members, you're going to have to make sure that you state that in your bylaws. So the process that you'll go through is a bylaw amendment process. You have to come up with the mechanism for how you're going to have these alternates. Of course, recognize that they have to comply with all the same training requirements. The only other issue, though, that doing it is, normally a lot of the bylaw amendments that you do, you can just send it to the department and it gets approved right away. Those that are structural changes to the board also are required to go before the Board of Neighborhood Commissioners. So you'll have one extra step that needs to be approved at that level. But there's not any type of prohibition against it. There may be other factors why they could decide to decline it, but nothing you're saying would.
Would your recommendation be that it absolutely only be addressed in the bylaws, or temporarily could it be addressed in standing rules?
You could not address an alternate in your standing rules.
Okay.
You have to address that in your bylaws.
And until it's addressed, we can't have alternates?
Correct.
Okay. Sorry, now I'll stop. Stop at the planning and land use, but I'm just looking at our standing rules here, and I'm the quorum of the quorum, the minimum, the 6. I'm seeing that this particular on page 4 of the standing committee rules, it's saying that they're planning in our planning, public works, parks and land use, 9 members, 7 board members, but that would in this case be
You should keep it
2
5.
more than the maximum.
Yeah, you want to keep that at. Okay, there's a way to do this. If you want to have more, you can have any number you want on your committees. All right, you can do it. You can do any way you want. If you keep it 5 and below, right, then you don't have that problem where you have potentially 6 who could potentially be a majority of your board making a decision. So if you're always under 5, you're okay with just noticing it as a committee meeting. When you have that 6, you have that possibility that when 6 people decided something, that they're also the board making a decision. So the best way to address the situation is to notice it as a joint board and committee meeting. So you could notice this as a joint board and budget and finance meeting, and then just put an asterisk on here. This meeting is noticed out of an abundance of caution with the Brown Act. However, it is really intended to be a Budget and Finance Committee meeting, and all recommendations from this meeting will be sent to the full board at a later date for a full recommendation. So you've noticed it, you've protected it to cover the whole board if you all want to show up and speak and talk there, okay? But it just impacts that how you. Most things under the Brown Act, it's all about notice. You can always fix most problems and address most situations if you just have the right notice under it. I saw you trying to write real quickly.
Yeah.
If you are, just check with the department. They have a template that you can use for that joint meeting structure that has that language on it. So you'll be able to get that kind of format if you decide that you want to have this number. Now let me just wrap up the thought real quick. Now, one of the things to remember that if you have noticed it, like let's say you had your planning committee and you did have the 5 members on there and you noticed it as a planning committee, right? And let's say one of the other members from the board happens to walk in and go to that meeting. Remember, that board member cannot discuss or talk about that meeting with anybody there. They can only sit in the audience as a participant. They're not allowed to get up and provide comments, so the chairs need to kind of be cognizant of that. Like when you're at that 6 limit, okay? If him getting up and talking would make 6, then you have that problem. So the chairs need to remind him. If they insist on speaking, okay, go ahead and speak. You're just.
They can speak in public comment.
Well, they shouldn't. I'm telling you, as board, if you do that, you should sit and attend as observers. If you feel really compelled that you've got to go to the committee meeting and also provide input, then we may have some cleaning up to do in the event there's ever a Brown Act challenge.
If you have a standing committee with 5 members of the board, and you have 4 members present from that committee,
You get one.
and another person comes in who's on the board but not a member of that committee, is
Yeah,
that going to allow?
yeah, you could probably get that person up to speak, but then everybody else won't be able to talk. See, because you're watching that, you noticed it as a committee meeting. You could have issues, but you watch the number. That's the number. It's like that's the key kind of part about it, because you haven't noticed it for 6 people there. And not that if it, and I'm not saying, and I want to make this clear, I'm not saying that if that did happen, it's always going to be a Brown Act problem. The problem with the Brown Act is I want to give you all the things to prevent any violation from ever occurring. So let's say that something happens and that you do get these, you do get the 7 people. You have your 5-person at the committee. You have 7 people who came to that meeting, and they insisted on speaking. They got up and they spoke before that committee meeting. All right. Now, normally you're going to think, "Oh my goodness, he told us we shouldn't do that." You shouldn't do that, but I'm not saying that that's a Brown Act violation yet. Okay. If they didn't speak, then I could tell you, you're never going to have a Brown Act violation. You don't have any problem. The problem with it is I don't know that there's a Brown Act violation until later on when your whole board gets together and I figure out what percentage of them were on the vote. So if it was still the 7 that showed up and they constitute a majority, there's only 6 other people there, then you have a Brown Act problem. If you had 8 people also show up, you don't have a Brown Act problem. So see, because there's this big gray area, I can give you the advice to best protect, because you always want to say, hey, we did it right. There's no way we could possibly have a violation. If you want to play in the gray, it makes things difficult.
And it sounds like the sort of hard line of the gray is where discussion starts happening.
Yeah.
And that's where you don't.
That's where it starts. Certainly after, if you have an issue where there's 11, then you easily at 11 you easily committed the violation. Okay. Between 6 and 11, that's really going to be fact specific. Okay, that's where I have a hard time telling you that's always going to be a Brown Act violation, that's not going to be a Brown Act violation. It's going to be dependent on how it all plays out. But obviously, you don't want to have Brown Act violation. If you encounter this, somebody can use this as a tool to tear you apart in an instant, okay? I could bring your board, if being savvy in the Brown Act, I can bring your board to a complete standstill with just giving you these challenges if I choose to do that, all right? So that's why you operate so that you're always above reproach and you'll never have these kind of challenges being brought to your board. I think there was a question here first, and then, okay.
I was just saying, so it sounds like that disclaimer that you just said would kind of cover all of those bases.
It does. Now, the other thing is, if you did have...
The one that you said to him about this is a joint meeting.
Okay.
If you did notice it as a joint meeting of the committee and the board, then you don't have that problem where all of you could come in and talk and then do it.
Okay, I don't want to start noticing, I don't think it's appropriate that every single standing committee be noticed as a joint committee or standing or ad hoc committee.
You guys,
let me finish.
You guys figured
be
it out.
Noticed as a joint. I just don't think it's appropriate. I think what the bylaws committee would like to do, or me as chair of the bylaws committee, is each standing committee would have no more than 5 board members on that standing committee. If another member of the board comes to choose to participate in a meeting, they participate as a member of the public, and they're only allowed to make public comment during public comment on a specific motion or agenda item.
They're not allowed to make public
They're
comment.
not allowed. So no. Okay. Then we'll put that in the standing.
Yeah. So those are the directions you guys can determine where you want to go.
Joint. I mean, it's like we already.
Mr. Martinez, may I? Because I was invited to participate in the meeting. May I?
No. I'm going to do the board presentation,
Yeah.
and then that's.
It's on this topic, and you said you wanted questions.
No. I'm here to present to the board. I'm
Okay,
sorry.
then-
I can talk with you after
Okay.
the meeting.
Then what I would do is I'll leave the premises, because I was invited to this meeting as a member of one of the subcommittees, and this is an issue that is very important to me as a former member of the board.
I can talk to you after the
No,
presentation.
that's okay. Thank you very much. Good night.
All right.
Wait. Roberto was next.
No, I was just going to address the same thing. It sounded like the panacea was notification and reporting back to the board. But now it's sounding also like, well, but don't have anybody talk, because that would cause problems. So that notification and reporting isn't necessary.
No, okay.
To solve the problem.
Two different types of committees, all right, that you have, ad hoc and standing. All committees come back to the board with their recommendations. What we're talking about is at those committee levels, when other board members show up at the committee who aren't on the committee, that's kind of what can raise a concern. So in either
Well,
case,
why is that? What is the concern?
because remember, under the Brown Act, you're required to have a notice of all your board meetings, okay? You can't have discussions with more than 6 people really outside of a public meeting, because then you have this problem with the serial communication. You know, the purpose behind it, obviously, is when a government entity makes a decision, they want the members of the public to see how that decision was arrived at. So if everybody here all kind of decided how you're going to, you all discussed and you voted on it, you all discussed among each other how you were going to decide an issue when it came before the board, then when the public got here, it would be like, on this one, motion, blah, yes, true, next, yes. I mean, it would be kind of set up, staged already. The idea behind the Brown Act really was that the public's entitled to see that debate or discussion that should go on. So that's why there's that prohibition or restriction on you having communications outside of public meeting. Now, when you get to that number where you have the potential of there being a majority action of your board, that's 6, that's when you have the concern with having it noticed as a meeting of the board as well. If you're going to exceed the number. Now your president indicates that, this isn't the problem. We're going to keep it under 5, so that way you don't have the issue. And the other thing, one of the cons also that I would say is, board members also need to remember to trust your committees, okay? If you have your 5-person committee, you need to kind of trust their recommendations, and when it comes to the board, you at that time have the ability to provide input. Your committee is going to come to you. You're going to still be able to provide that input at the board meeting. That really is the appropriate pace and best place to do it. If you set up your committees, let them do the work. You don't necessarily need to go. If you need to go to see it, you can watch and as observer. All right?
So
Kind
it
of
seems
clear
like
as
the
mud?
responsibility is on the committee chairs to make sure that line doesn't get crossed within the committee.
Like I say, the committee chair should remain cognizant of it. Each of you as board members should remain cognizant of it. Because this can be an issue that could be used to, say it's an important issue that your community really wants to provide input on. Follow the process so that somebody doesn't undermine what you want to do. Because that's the easiest way to attack you. You mess up on the process, it's the easiest way to attack you and undermine what you're doing. Get the process right and your decision can't be challenged.
Seems like just hardwiring it to the standing rules is probably the best way.
Okay. Any?
It's my understanding that our standing committees are composed of 5 members, 3 board members and 2 stakeholders. So where did you get the 5 board members from? We can raise it as high as 5?
You can raise it as high as 5.
How about the stakeholders?
You could have any number.
We could also raise the stakeholders.
Yeah, the only number that I'm concerned with for purposes of the Brown Act is the 5 number. The one item, though, that I would want to mention that you really want to be careful about is when you are having a lot of members from the public participate on these committees, you want to make sure that you're also being proactive and providing them with the tools that they need to use to be able to be involved in these decisions. Ethics, so that they're aware of public records, because they come in and they're under the umbrella of all these things. They need to realize, like, hey, when I'm writing emails now, these may be things that might have to be turned over. So, everybody should be you may want to make sure you have your manual with a nice set of handouts, even to have your committee members review. So they may come into it not thinking like, oh, I can just show up and do it. And no, there's a host of rules and laws that they have to be cautious with as well. So, and that's kind of on, that obligation on your board, if you're going to do it, to make sure that you have those learning tools available to them as well. And we can help you, as well put those together. One other thing that I just want to emphasize. We did. Sorry.
I'm just curious, because I heard at one point that Don was thinking about, what's the word, unionizing all the bylaws, they all read the same for every single neighborhood council. Is Don ever going to do that?
I don't know. I can tell you in the past what has happened. I wish I could tell you I knew everything that would happen. I would play the lottery. What has happened is the department has standardized the format that you use for your bylaws. So all neighborhood councils, when you look at them, they're going to have the same format as yours do. You know, Article 1 is going to deal with your name, Article 2 is going to deal with your purpose. So they're all that way. The language can be different, though, for all the neighborhood councils, and it reflects the variety of interests throughout the city. There may come a point in time when specific provisions become more standardized, like perhaps the grievance process will become standardized so that it's applicable to all neighborhood councils. But that's something that you know, is kind of in discussion right now. I don't have a sense of whether it'll happen or not. One other thing I just want to touch on real quickly, and that's with respect to the expenditure of monies. Remember that, you know, as neighborhood council board members, you're charged with taking care of these public funds. Now, since you are dealing with public funds, you have to be careful because there's some personal responsibility assigned with this. The first thing that you have to ask yourself is, A, there has to be a public purpose behind every expenditure, okay? I can't buy a Lois a television set, all right? There's no public purpose in that, you know? She gets a television set, how's that benefit the public? You know, so you have to be able to think about that, articulate, well, what's the public purpose behind this expenditure, all right? The next is there's 3 things that neighborhood councils are able to use their monies on, all right? You're able to use it for your administrative expenses, all right? That includes your outreach, you know, how you operate your office. For neighborhood improvement projects with the approval of DUN, I'm going to emphasize that, with the approval of DUN. Right? So if you want to work on a median project, you work with your project coordinator to get that approved. The next is neighborhood purposes grant. Right? That neighborhood purposes grant is when you provide a grant of monies to a nonprofit or a school for their use as a public purpose. What you cannot do is you cannot use your demand warrant process or your P-card purchase to give monies to nonprofits. Okay, it's a separate process that you need to go through. You need to go through the NPG, the Neighborhood Purposes Grant process, anytime you intend to give that gift or donation to a nonprofit. Or school. You can't use your P-card or demand warrant process to do that.
The P-card can only be used for our own administrative expenses.
Pretty much, yes.
You can't, for example, go to Home Depot and buy a bunch of stuff and give it to a school.
Exactly.
Okay.
Can the P card be used for outreach? This is all going to change, isn't it?
Yeah, you know what? I don't want to get too much into P-card questions because you're right. This is going to, you know, there's a new system. So I want to just stick with that general areas. You know, those are kind of the mechanics might be a little bit different within the next couple of weeks because you're going to be, the checking account's going to get rolled out. But, you know, the ideas, though, about what the expenditures are that you're allowed to kind of use. So always keep that in the back of your mind. You know, public purpose, that's the biggest thing, okay? Then the next one is, are we following the right process for for what we're trying to achieve? Whether you're doing that neighborhood improvement project, the neighborhood purposes grant, or you're dealing with the office expense. Okay?
And what's the relationship between DUN and the city attorney's office as far as enforcing these policies?
Well, the department has complete oversight over the funding program. So the department, you know, when you say oversight, yeah, to some extent, yeah, they have oversight of it. They can, you know, compel your neighborhood council to do certain things because of that. They could cut off the funding. They can control the money. With respect to our office, okay, we are not an investigative agency. Let me go into that a little bit too. We're your legal advisor, okay? The same way that we are for the Department of Neighborhood Empowerment. The same question that you ask us and the same question that Dunn asked us, you guys both get the same answer. You know, you're getting the same legal advice on these issues. All right? You're in that same situation as the department with respect to our office. You're our client. The communications that we have with you in writing or outside of a public, obviously, this is public, so everybody here is kind of, able to hear that or discuss that. But when we deal with confidential issues or problems and we write you and we respond to you, that communication is protected by the attorney-client privilege. So that's one type of, that's a document that's not subject to disclosure.
Communications between Dunn and our board.
No, the communications between our office and your board.
When you say our office, you mean city attorney?
I mean, yeah, city attorney's office, yes. Okay, well, thank you. If there's one another question here?
Yeah, you said that we couldn't use demand warrants to fund schools, but we do use demand warrants to fund schools through the MPG.
Yeah, from now on, when you want to give money to the schools, use the MPG process.
Well, the MPG requires a demand warrant.
Well, I mean it more like with using your P card, but you have to make sure, make sure that the MPG precedes the demand, because you can also get the demand warrant without going, the MPG, that precedes anything. It does get paid out through the demand warrant, but you can also have things paid out through the demand warrant that aren't going through the MPG. Do you follow?
An MPG goes with a demand warrant, or demand warrant goes with an MPG.
Sometimes. And if you do the MPG, you've always done it right. Okay, just make sure you do the MPG when you want to get the money to the school or to a nonprofit.
Okay, but one of the requirements is a demand warrant.
Yes, if your MPG is approved, then a demand warrant will be issued. What I'm saying is, don't request that the department issue a demand warrant without having the MPG first. If the department gets the MPG, they will use the demand warrant to pay it. But you can also request demand warrants.
Well, a demand warrant
They're
is
two
just a
separate,
piece of paper that
yes.
you're applying.
Yes.
And you fill, and you submit all the information, you compile it, and you submit it, and then it's up to Dunn to decide whether to pay it or not.
Right.
So just because you complete a demand warrant doesn't mean it's going to get paid.
Correct, and I'm saying make sure that you have the MPG first before you're requesting these payments to the school or the nonprofit.
Right. Oh, right. Yeah. It's always, okay, thank you.
And I'm sorry, are you a deputy city attorney? And what's the name of your division?
The Neighborhood Council Advice Division.
So, I gather you're about to wrap up.
I'm done. If you guys, as much as how long you want me here.
I'd like to suggest that the board look at the agenda item 4 and just make sure you don't have any questions you'd like to ask at the time. One of the things that's come up is the conflict of interest laws in the Neighborhood Council. I think people have some concerns about that. My understanding of it is that if you're not standing to directly benefit from a decision that the board's going to make, you don't have to recuse yourself based on a conflict of interest. Is that what you're elaborating?
No, let me give you an easier test, okay? If you can see any contact or any relation between the person who's standing here before your commission or before your board making a request, contact our office for help, because the rules can be very, sometimes there doesn't have to be any monetary relation. An example of that, your brother, okay? If you have dependent children. Things that impact your brother, your dependent children. So they can be things that aren't necessarily monetary related. One of the biggest things I want to point out is, like in the context of the Neighborhood Purposes Grant, a lot of times board members also hold a seat on one of these nonprofits, all right? So you think that, by holding a seat on a nonprofit, you're not paid, you're not making any money. But the way the rules define that is a financial interest, okay? So you being seated on a nonprofit is a financial interest. If your board wants to give money to a nonprofit that you're also seated on, you have to be extremely careful in that situation, or the whole thing's going to get thrown out. You as the board member who also has that seat on the nonprofit, you can't discuss it with other board members. You can't sign the MPG application requesting the money. You can't sit in the room while the item is discussed. When the matter does come up for discussion, you have to announce your recusal. I'm seated on this nonprofit. I'm going to recuse myself from discussion of this item because I've sought the advice of the city attorney, so I know what to do in this case. And then you get up and walk out the room. You're recused. You can't sit in there while it's being presented. You can't do anything. You're completely disqualified. If you follow those rules or process, then when your co-board member on your nonprofit comes up and makes a presentation to the board for the request for money, your board could decide to provide that funds to them. But that's why you have to be very careful. So these conflict of interest can come up in situations where you may not perceive. That's probably, familial relationships and nonprofit are probably the most problematic, sometimes for people to grasp or understand.
It becomes a little bit difficult at times when you have a former teacher and another teacher who's currently working, sitting on or chairing the education committee. It's a natural fit. But if their interest is in strongly advocating for the schools, then where does the line get crossed?
And this is part of the reason why when you have a question, talk to us, okay? While we do serve as the board's attorney, we also will strive to keep that discussion that we have with you as an individual confidential, okay? That doesn't mean that it's entitled to the same protections, because there might be situations where, if you came to me and you told me, hey, I secretly have this business that our board is about to enter into, our $20,000 contract with, ha ha ha, and you laugh, right? And you're like, you can't tell anybody now, right? No, I can still tell the board you can't enter the contract with it, sorry. So there's situations where, that disclosure is, we're here to help you in an individual capacity. But let's see, did I get the bulk of the question you were asking?
More or less.
The educational person, right?
Well, yeah. I mean, if like my kid goes to Logan Street School and Logan Street School applies for an MPG.
Are they LAUSD school? I'm sorry.
LAUSD school.
Okay.
I don't think under the ethics code of the city I have to recuse myself from making that decision. But
is this a possible real question? Let's discuss that in private then. We'll discuss it in private with you. So yeah, feel free to contact Delos. But we'll look into it. There's probably a few more factors that we want to explore with it. What exactly is that involvement with the school, with your child's activities that you may be paying for there. So it's a little more. They're always a little bit more complicated and very fact specific. Maybe not be a conflict, but let's flush it out and make sure. But let's have these conflict discussions privately. I'm sorry, I didn't know who was next. I did. Okay.
I guess this has to do, I guess I might have to talk to you this privately, but I'm going to throw it out there generally. So if in the past, let's say, board members belong to a nonprofit and they voted for projects for their nonprofit and they were totally in the wrong?
I'm not saying, okay, let's look at this as a new day. We've come down here as a tool to help get you guys going forward in a positive and proactive way. We understand that everybody here is committed to their community and doing things the right way, and so that's what I'm not gonna get into details about what may or may not happen at this point in time. But I'll make a commitment to improving the community and doing the best we can.
So I'm hearing it's a possible conflict. But we should be using our well sense that if it comes up for us,
contact our office, and we're here to help you. Don't go out on your own. That's the mantra.
Wait a minute. Hang on a second. Sue.
My question's a little bit more generally. I think that a lot of us are also involved just as volunteers with a nonprofit that may receive some funding from GenTech. Now, just as a volunteer, you're not on the board. You just go for a few hours a week for a few weeks. Going forward, or even into the funding, is that starting to turn a little gray?
Again, let's talk about these situations when they come up in a very fact-specific way,
Oh, I
because,
can get various facts.
well, no, no,
I might be
but we'll do it,
volunteering for the-
no, no,
for the
but let's
rec.
do it, let's do that
But I
in a
know it's not
one-on-one
fine, just-
conversation. You know, it raises an issue. Now, let me preface that by saying, because you're throwing other factors at it, you know, what are they doing volunteering? What exactly does that work? These can kind of color what may or may not be. Remember ultimately too that, you know, if a reasonable person would perceive that there's no way that you could operate without a bias under the situation, then there's some concerns with conflict of interest rules, you know. Now, there are laws or rules that say, you know, simply being a member, all right, simply being a member of the organization, not on the board, not on this, that's not gonna, that there is the ability to move forward there. But depending on, I guess, your involvement with that nonprofit, that can kind of color what may or may not be going on underneath it. So I don't want to say that in all cases it's a yes, or in all cases that it's a no. In most situations, you are able to act in a situation where you're simply a member. Let me give you an example, though, okay? Let's say that I am a member of the Sierra Club. All I do is I carry the card and I get the magazine, all right? Now, the Sierra Club comes before my board, and they're asking for money for, you know, some worldly purpose, all right? Now, in that situation, right, I'm just simply a member, and I'm going to disclose it to the board. You know, I'm disclosing that I'm solely a member of this organization. This is the extent of my contacts here. I'm able to vote on that matter, and the board is still able to enter into the agreement. Now, if you color it with other facts, it can change the answer. So that's why I want to be very careful with conflict of interest questions or analysis, and go into those more in detail on a one-on-one basis.
Well, again, I wasn't going to necessarily, you know, I was going towards somebody just spending a couple of hours volunteering, and then they come before the board looking for funding. I mean, we all volunteer in our lives.
Okay.
And so I was trying to make it as general as possible.
Let's talk.
The widest scope possible.
Let's discuss that with you. Like, what exactly are you volunteering for? What
I-
is the nonprofit?
Let's
We'll
not
do that
talk-
in private.
Let's not
but-
talk about the specifics. Cat was in.
My understanding is that if there is an ethics violation, or is later found that a conflict of interest has occurred, that what is in jeopardy is the contract, essentially. So that it can result in reversal of the contract. That's pretty much, and then there could be, I mean, if there's...
No. When you're talking about Government Code Section 1090, okay, this is the death penalty of the conflict of interest laws. This is felony for you as board members. Is it prison time
I'm
for
more
you as
talking
board
about the
members?
kind of thing where my kid goes to Logan School got an MPG, I voted, people know that, I don't know, whatever. I didn't benefit from that directly. It's nothing that would be considered felonious in that sense, but the possible ramification is that Logan wouldn't get the money, is the most likely first step that would happen there. Is that correct, or is that,
Well, the first step is, if there is a 1090 violation, the department won't pay the funds. So that's the initial step. If the funds do paid out, that's what can cause some severe and significant consequences. So, for each person. If you're concerned that your board member has an interest in a contract that your board is approving, please notify our office. I mean, that's something significant for each of you. If you think that that's going to happen, get out of the room right away. Don't be involved in it, because the felony applies to everybody.
Is there intent?
Yeah, you don't have to have intent for it. I mean, that may
Really?
carry out in it may carry out in the terms of somebody feeling sorry for you and not convicting you. But
Wait a minute.
Isn't it mens rea a specific element of the felony?
no, not with some felonies. They're like strict penalty, some of them, and this is what 1090 does.
So for anyone in the room, when that vote is taken.
You need to be very cautious, okay? So that's why I'm emphasizing, be very cautious when there is a contract or a recommendation on a contract or an expenditure of funds happening among and between your board. Okay, you don't want to go down the path where there's these potential 1090 violations.
Okay, but I just want to say, the bulk, all these questions really pertain towards expenditure of funds and contracts.
Correct.
And the conflicts of interest will primarily apply to financial interests, not
No,
necessarily.
no, they apply to everything you do.
Benefit.
Yeah.
It doesn't have to be
If,
financial.
if let's say I'm a developer coming before your board for approval of a CUP, okay? You're not entering into any contract or agreement with me, but you're going to provide your recommendation to the city on me as a board developer, all right? If you have a relationship with that developer, that can also result in your disqualification. The penalties of that are very different, though, from when you're dealing with that contract. But you still have the ethics issues or concerns. So if you have a relationship with that developer in any way, then there are requirements that you be disqualified from hearing that matter when it comes before your board.
I mean, what do you mean by relationship? Like,
If there's a financial relationship, if you're an employee, if you're an attorney, if you're an agent, if they've given you gifts, if they've if there's a relationship that you can articulate with that developer, there's probably some reason to cause concern that you'll want to look into and follow up with our office if there's a need for further analysis or review.
does everybody have Lois's contact information?
I was going to ask.
Yeah.
ALOIS dot PHILLIPS ALOIS dot Phillips PHILLIPS at lacity.org. Does anyone want a phone number? An email works for everybody. Go through Lois. She's your advisor.
Phone number.
My name's Darren Martinez.
Okay, I'll take Lois's phone number.
213-978-8132. 32. All right, you guys. Thanks a lot. You have a good night, okay?